Call.
Good afternoon, gentlemen.
Good afternoon, my lord.
Hear me? Good afternoon.
Good afternoon, my lord.
Very well. We'll go through the judgments and the appeals serially. Registrar, call the first one.
The court pleases. Judgment in appeal number CA/OW/EPT/SE/1/2021 between Charles Onyirimba and another and All Progressives Congress APC and another.
We have the council's list. Thank you. Parties? Parties absent? Registrar?
Parties absent, my lord.
Appearance? Who appears in this appeal? Dr. C.C. Nwadigo. Is he still with us?
Sorry, my lord, CC Wadiwo seems to be having trouble with her network, trying to reconnect.
Yes, Dr. C.C. Wadigo appear for All Progressives, particularly Honorable Court. Dr. C.C. Wadigo most humbly appear
For the first respondent. Is Mr. Okomanko with us? For the second respondent, Mr. Okomanko, are you here with us?
No, it's because the cloud they are using. It's not that.
Yes, my lord.
This is mute.
Sister Okomanko, you are there for the second respondent?
This is mute. Hello?
Yes, Mr. Okomanko, we have recorded you for the second respondent.
Hello, my lord. Okay.
Yes. Now, this appeal was heard by a panel comprising my lords Honorable Justice Abubakar Dati Yaya, my Lords Abimbola Obaseki Adejumo, and my humble self. This is the lead judgment as written by me. This is in respect of an appeal against the decision of the National/State House of Assembly's Election Petition Tribunal holding at Owerri. Delivered a petition number APT/OW/SCN/2/2020 on the 25th day of February 2021. The second respondent conducted a senatorial by-election to elect a senator for the Imo North Senatorial District, which election was held on the 5th December 2020 across the said Imo North Senatorial District of Imo State. The first appellant was sponsored by the second appellant as his candidate in the said election, in respect of which a result was announced by the second respondent on the 6th December 2020, declaring the first respondent as winner. Dissatisfied, the appellants filed a petition at the lower tribunal on 24 December 2020. The grounds for the said petition were stated, which will be taken as read. The two respondents filed separate replies to the said petition, and thereafter the second respondent to the said petition, now first respondent on this appeal. In this appeal, filed a motion on notice on the 16th February 2021, pursuant to paragraphs 18 and 47 of the first schedule of the Electoral Act 2010 as amended, at the inherent jurisdiction of said tribunal, wherein it sought the following orders: an order of this honorable tribunal dismissing the instant petition filed on the 24th December 2020 as abandoned and for want of jurisdiction. The said application was supported by the first respondent to the petition as second respondent to this appeal, and was expectedly opposed by the appellant. After hearing the submissions of counsel, the Learned Law Tribunal delivered the considered ruling on as aforesaid on the 25th February 2021, where the said petition was dismissed as having been deemed abandoned. Dissatisfied once again at this outcome, the appellants invoked the appellate decision of this court via the notice of appeal filed on the 3rd March 2021, containing 6 grounds. Briefs were filed by the appellants and the first respondent, while the second respondent, which was duly served with all the present and was represented at the hearing of this appeal, failed to file a brief. Now, the appellants distilled 5 issues which were notable for their inelegance. The first respondent filed a loan issue. But before considering the issues, the court considered the preliminary objection raised and argued in the brief of the first respondent. The appellant failed to respond to the said plenary objection, although they were well aware of it. While this ordinarily indicates that we are considering the plenary objection, the court still has a duty to consider the objection on the merits. This was done. The objection was as to the incompetence of the notice of appeal, that it was not properly signed. The court considered arguments on this issue and the position of the law, and came to the conclusion that the notice of appeal in this instance carries a signature under which the names of 4 legal practitioners were listed, without any of them being ticked as the owner of the signature. The signature itself is not decipherable, and while the seal of a legal practitioner, Akporo Genepi Ugefere, was affixed to the said process, an attempt to tie the signature to the said legal practitioner fails on examining the signature on the appellant's brief dated 1st April 2021 and clearly indicated as belonging to the council by that same name and seal. The signatures on the appellant's brief and notice of appeal are as far apart as the sun is from the earth. As it stands, therefore, there is no relationship between the signature and the seal of the legal practitioner affixed on notice of appeal initiating this appeal. The signature cannot therefore be identified as belonging to any of the names listed thereunder. The signature of the notice of appeal should not be such as will need to be resolved by forensic investigation. It is the duty of legal practitioners signing a notice of appeal to properly identify their signatures to meet the requirements of the law. The seal affixed to the signature in notice of appeal initiating this appeal cannot be reconciled with the signature thereon, and neither can the said signature be tied to any of the names listed under it with any degree of exactitude. This error renders notice of appeal incurably defective and incompetent. As earlier stated, the law is clear that an incompetent process is incapable of conferring jurisdiction on the court. The situation in this case is compounded by the fact that the competent process is the notice of appeal, which is the foundation of this appeal, and without which the appeal has no valid existence. It goes without saying that something cannot be placed on nothing. The plenary objection there succeeds. This appeal is and it's accordingly struck out. Parties shall bear their respective costs.
As the court pleases.
As the court pleases.
As the court pleases.
My Lord, Abubakar Dansiyaya, and he agrees completely with the appeal. He agrees completely with the judgment. I agree with the reasoning and conclusions therein, and I also abide by consequential orders made and agree that the appeal is struck out and is struck out.
As the court pleases.
As the court pleases.
For the records, were the appellant served with the notice of appeal, with the hearing notice for this appeal, for this judgment?
Yes, my lord.
On what date?
On the 20th of April, my lord.
As the court pleases. As the court pleases.
For the next one.
Judgment. Appeal number CA/OW/EPT/SEN/2/2021 between Allied People's Movement, APM, and Independent National Electoral Commission and two others. Parties are absent, my lords.
Thank you. Appearance? Who appears in this appeal?
Lord, with greatest respect to Millards, my name is G. Ofomabu. I appear for first respondent INEC.
Mr. Ruben, are you with us? Mr. Ruben, is this still
yes,
live with
my
us?
Lord. Yes, sorry, my Lord. The network is bad, my Lord. My name is Ruben Igwaba, my Lord.
Igwaba Ruben. Who is with you?
Yes, appearing with me is Ikojo Kubile, my Lord. Our humble appearance is for the appellants. Thank you, my Lord.
Dr. Wadigo stable with his network now.
Yes, my lords, I had earlier announced my name.
So you announced
my
for
noble,
first. Yes.
no, my noble lords.
Dr. Wadigo is for all whenever APC appears. Is he here with us?
Okay, my lord, sorry. Yes, my lord, Dr. Sisi Wadi respondent, my lord. I'm sorry, I most humbly appear for the second respondent.
You are for the second and third, or for the second and third, right?
Second.
Yes, my Lord. Second, Lord. Second.
Yeah, for second respondent.
Dr. City wanted to marry.
Who is for the third respondent? Mr. Matthew?
Yes, my lord. Yeah, Matthew, my lord.
Judgment.
As
This
a court, please.
appeal was urged by a panel comprising my Lord Honorable Justice Abubakar Dati Yahya, Abimbola Obaseki Adejumo, and my humble self. This is the lead judgment as written by me. Yep. This is in respect of an appeal against the decision of National/State House Assembly's Election Petition Tribunal holding out to Willie. Delivered a petition number EPT/OW/SCN/5/2020 on the 27th day of February 2021. The first respondent conducted a senatorial by-election to elect a senator for the Imo North Senatorial District, which election was held on the 5th December 2020 across the said Imo North Senatorial District. The appellant, being a registered political party, sponsored a candidate in the said election, respect of which the result was announced by the first respondent on the 6th December 2020, declaring the second respondent winner. The second respondent, who sponsored the third respondent as candidate, said election as winner. Dissatisfied, the appellant filed a petition at the lower court, the lower tribunal, on the 25th December 2020. The ground for the said petition was stated as follows. I want to take that as read. On being served, the second and third respondent filed a joint reply to the said petition on the 22nd January 2021, while the fourth respondent filed his own reply to the petition on the 25th January 2021. The appellant thereafter filed an application for pre-hearing session and scheduling, pursuant to paragraph 18(1) of the first schedule to the Electoral Act 2020 as amended on the 5th February 2021, answers to the pre-hearing information sheet on the 12th February 2021, and his issues for determination on the 26th February 2021. The pre-hearing session started on the 19th February 2021, and in the course thereof, on the 27th February 2021, the learned senior counsel for the second and third respondents applied that the petition be dismissed on the ground that the appellant, in filing answers to the pre-hearing information sheet on the 12th February 2021 and its issues for determination on the 26th February 2021, had breached the provisions of paragraph 18 of the first schedule to the Electoral Act Supra, and the said processes were filed outside the stipulated 7 days period. The application was supported by learned counsel for the first respondent, but was opposed by learned counsel for the appellant, who contended that the provisions of paragraph 18 of the first schedule to the Electoral Act was not breached by the appellant, as according to the said learned counsel, there was no stipulation of a mandatory 7-day time limit for filing of issues for determination simplicity. The trial tribunal in its ruling delivered on the same 27th February 2021 considered the contending positions and ruled that the appellant was indeed out of time in filing his pre-hearing processes, upon which the petition was dismissed. Dissatisfied, the appellant invoked the appellate jurisdiction of this court via the notice of appeal filed on the 2nd March 2021 containing 6 grounds. At the hearing of the appeal, Mr. Rubin adopted the appellant's brief filed on the 16th March 2021 as the evidence of the appellant. The first respondent failed to file a brief, although it was duly served with all the processes and was represented at the hearing, while the joint brief of the second and third respondents filed on the 19th March 2021 was deemed argued in opposition to the appeal. Appellant distilled 3 issues for determination from the 6 grounds of appeal. Second and third respondents of the part distilled a lone issue from the 6 grounds of appeal. The court, perusing the 2 sets of issues, adopted issues for determination formulated by the second and third respondents, and considered all the arguments of the 2 sides on this issue. And after considering the arguments, it was held thus. It is tried that where the words of the statute are clear and unambiguous, they shall be given a simple and ordinary grammatical meaning, unless to do so will result in absurdity. No, the limitation of time for completion of electoral disputes was put in place to sanitize the electoral process and save it from an endless procedure, which had the potentials of foisting on elected officials on the electorate indefinitely. This therefore necessitated an effective case management strategy that will ensure that no litigant is granted the leeway to fib or play around at the expense of the judicial system with attendant negative consequences for the peace and stability of the nation. To enable a proper appreciation of the reasoning of the trial tribunal, never at its decision to dismiss the appellant's petition, I hereby quote in extenso from the first decision as follows. I will take that as read. It is tried that the words of the statute, where the words of the are clear and unambiguous, they are given a simple and grammatical unless to do so will result in absurdity. The clear words of paragraph 18(1) of the first schedule to the Electoral Act places the burden of applying for the issuance of pre-hearing notice on the petitioner within 7 days. He must make the application within the limited period or face the sanction contained in paragraph 18(4) thereof. The words of that paragraph 18(4) were reproduced. It is abundantly clear that what attracts punishment or sanction of dismissal of petition is the failure to apply for issuance of pre-hearing notice within the stipulated period of 7 days. The trial tribunal allowed itself to be misguided by counsel and expanded the scope to include filing of pre-hearing notices outside the clear and unambiguous provisions of the law. While it is appreciated that election tribunals face tremendous pressure from the enormity of their workload and the severely limited period within which they must conclude their onerous assignment, the urge to summarily dispose of petitions must be resisted. As has been seen globally, electoral contests come with high emotional volatility. The integrity of the electoral process is therefore essential, and it is reinforced with the possibility to challenge the outcome by the contending parties. The role of the judiciary in those events is only relevant to society where there's public confidence. Resort to violence in electoral disputes is avoided or minimized when the judiciary as the final arbiter enjoys considerable public confidence. As it is, the task placed by the electoral or the petitioner challenging the outcome of an election is daunting, and it would be unfair for the judicial arbiter to further compound the situation. Evident on pages 260 to 267 of the record of appeal is the application made by the petitioner through his regular representative for the issuance of pre-hearing notice. The said application of those dated 2nd February was filed on the 5th February 2021, the very date pleadings were completed by the parties. That certainly is not consistent with the posture of an unsealed petitioner, with the provisions of paragraph 18(1) to 5 of the first schedule of the Electoral Act as amended 6 to do away with. Pursuant to the said application, made promptly by the appellant's counsel, pre-hearing of the petition commenced on the 19th February 2021, from which date it continued on the 24th February 2021, 26th February 2021, and eventually on 27th February 2021, where the said petition was dismissed for being abandoned. All this can be seen on pages 282 to 299 of the Record of Appeal. In the arguments against the appeal as contained in the second and third respondents' brief, reference was made to a number of cases. The court analyzed those cases and found that none of the cited cases relate to time for filing of answers to pre-hearing information sheets or issues for determination after pre-hearing was duly applied for and was in fact ongoing. I have no difficulty in coming to the conclusion that the trial tribunal was in error to have considered the petition of the appellant as abandoned in circumstances presented, and was therefore also in error to have dismissed the said petition. Election cases are sui generis and time-bound. Time lost to this avoidable error cannot be retrieved. It is most unfortunate. I therefore resolve the sole for determination in favor of the appellant and against the respondents. This appeal is meritorious, and it is accordingly allowed. Consequently, I hereby set aside the decision of the trial tribunal to which the National/State House Assembly's Election Petition Tribunal holding that will be delivered on 27 February 2021 in petition number EPT/OW/SEM/5/2020, dismissing the said petition for non-compliance with the provisions of 18(1) of the first schedule to the Electoral Act 2020 as amended. The said petition number EPT/OW/SEM/5/2020 is then remitted to the said tribunal to be determined expeditiously on the merits. Parties shall bear the respective costs.
As the court pleases.
Well, my learned brother Abubakar Dati Aya JCA sent in a contribution. He too is in complete agreement that the appeal has merit and is allowed. He abides by consequential orders made. I was also on this panel and I fully adopt the eloquent reasons so set out in the lead judgment as mine. In addition, I find that the appeal is meritorious and is accordingly allowed. I also abide by consequential orders made in the leading judgment.
As the court pleases.
As the court pleases.
Thank you.
Yes. My lord, on behalf of the appellants, we thank your lordship for the industry in this judgment, despite the strike and that more so that the matter is time bound. We have been so worried, and we thank God that our hope has been restored. Thank you, my lord.
Thank you. Registrar, please call the next one.
As the court pleases. Judgment. Appeal number CA/OW/3/2021 between All Progressives Congress and E. Okewolunu and 4 others. Parties are absent, my lords.
Who appears?
Most
Who appears in this appeal?
Doctor,
why do you appear for the appellant?
TC want to go. My lord, for the appellant. What's up?
Hello, my lords.
Yes.
Hello,
What's up, Mr. Olajide, for the third respondent? Are you still with us? Mr. Ofamago, you are for the...
Yes, my lord.
Okay. Mr. Olajide, you are still here for the third?
Olajide for the third respondent cross appellants.
Of course, Mr. Ofamago, you are still here for the fifth.
Yes, my lord, G of Omabo for the 5th respondent. Thank you, man.
Learned brother,
Well, this judgment was prepared by my good self on behalf of the panel, so I proceed to read. Judgment is an appeal against the judgment of the National and State Assembly's Election Petition Tribunal sitting at Owerri, contained in its decision of the 24th of February 2021, whereby the tribunal set aside its ruling of the 22nd of February 2021, setting aside a motion filed on the 20th day of February 2021, praying the tribunal for an order striking out the respondent's name from the petition based on the judgment of the Supreme Court in suit SC-971/2020 between Ararume against Ibezim, delivered on the 5th of February 2021. This appeal arose when the tribunal took a decision on the 22nd of February 2021 to hear a motion but changed his mind to take the appellant's motion alongside with the petition by virtue of section 285, subsection 8 of the 1999 Constitution as amended. Appellant is satisfied with the tribunal's decision, filed a notice of appeal on the 4th of March 2021. See pages 387 to 386, 386 to 387 of the record. Appellant's brief is filed on the 11th of March 2021. The reply brief to the first and second respondent's brief filed on the 18th of February 2021, of March 2021, and replied to the third respondent's brief of argument filed on the 19th of March 2021, respectively. And then they formulated two issues. The issues have been reproduced in this judgment. First and second respondent's brief was filed on the 24th of March 2021, and it distilled with sole issue for determination. We have reproduced same. And the third respondent's brief was filed on the 17th of March 2021, where it distilled the third respondent, and then the fourth respondent distilled two issues for determination. We have reproduced all for same in this judgment. The appellant's arguments and all the respondents' arguments were captured in this judgment. I should just proceed to make a pronouncement on our resolution. Okay, our main questions to be answered herein. One, how did the ruling emanate? What exactly transpired at the tribunal of the 22nd of February 2021? The first respondent had filed a motion asking that for an order granting leave to the first respondent to move and argue this application during or outside the pre-hearing session. Two, the name of the second respondent may be struck out for being improperly joined on grounds that, I'll go straight to D. That is that the said judgment has been set aside or quashed by both Court of Appeal and Supreme Court. And also that the second respondent's name be struck or to be struck out for being improperly joined. Now, went ahead to reproduce what had the event that happened on the 22nd. That is, Chief Ajano SAN, counsel for the first respondent, asked that the application be heard if counter affidavits are served on him. And later in the same breath at pages 382, it suggested the addresses be adopted and ruling on the application be heard and ruling delivered before the adoption of the final address in the petition. Second respondent counsel Nwosu Esquire was of the view that the motions be carried along with other motions for determination by the tribunal at final judgment. While Matthew Esquire, counsel for the third respondent, agreed with the submission of the petitioners and the first respondent that both applications be taken before the full trial so that the width can be separated from the chaff. Petitioners counsel Dinigwe SAN was of the view that they canvassed in the counter affidavits that the application should not be held now. At page 384 of the records, tribunal chairman adjourned the application to 24th of February 2021 for hearing, while other applications and interlocutory applications can also be taken and adopted alongside the final written address of the main petition. At page 385, the parties were represented except fourth and fifth respondents. The tribunal delivered the ruling on the arguments of the previous sitting, held in its ruling hereunder reproduced. I reproduced the ruling of the tribunal, which is the ruling under attack here. It's therefore correct that the tribunal gave no indication that the issue of the procedure was to be adjourned to a ruling, having at the previous proceedings held that it would hear the application on the 24th of February 2021 for hearing, neither notified the counsel of the ruling. In fact, there was no application on the 24th, and addresses had closed with the adjournment of the 22nd of February 2021. The adjournment on the 22nd was for hearing of the application. Instead, strangely, the parties met a ruling on arguments of the 22nd. I agree that it was the wrong procedure adopted. Tribunal stated that the first and third respondent left the issue at the discretion of the court. This is not borne out by the record of proceedings of the 22nd of February 2021. It was not the third respondent. He aligned with the first respondent that the application be taken before the commencement of trial. However, the record of the address of my respective counsel as captured by this judgment has not been challenged by the appellant by way of any affidavit. Having not done so, is bound by the contents and cannot argue contrary. Well, we relied on the host of cases and decisions of the Apex Court. The submission that some parties were absent is not tenable because the proceedings was adjourned in their presence for hearing till the 24th. Any counsel who did not attend court in person or by proxy on the 24th, date of the adjournment, cannot complain. This in law is neither here nor there. Their proceedings will go on, and no breach of fair hearing can be alleged, relied on a host of cases. Well, on this issue, we said the issue, what is the effect of the wrong procedure? Has it caused any miscarriage of justice? Further, having changed the stance and based its reason on the provisions of the Constitution and Electoral Act, the appellant contended at page 15, paragraph 24 of his brief, that there are negative implications of the tribunal's reversal of his decision to determine the appellant's motion, which include but not limited to giving the third respondent license to cross-examine appellant witness, ask and lead questions from the first and second respondent witness to destroy the appellant's case, exposing the appellant to attack from the first and second respondent and third respondent, lead evidence in chief against the appellant defense, litigate issue, and a host of other complaints. These are futuristic issues which can be handled during the trial and cannot be a basis guiding the discretion of the court when the reason is for the motion. When the reason is this motion is based, for this motion be based on the Supreme Court's judgment. I'm therefore persuaded that this cannot be equated to a miscarriage of justice. Apart from this, nothing is on record said to have been grave results of the reversal. The appellant is not complaining about the reasons for the change in the procedure, but, in quote, the sudden twist without notice, the manner of change, which I believe is correct, but he can question this. When the light of the reasons adduced and worst effect of hearing the motion before trial, filing this appeal would not erase the loss of time and the tangle to be created in the light of the provisions of the law. Limited time within which to hear and the entire petition, definitely. I dare say that the discretion is entirely that of the tribunal. The appellant had disagreed that the application is not an objection under section 12, subsection 5 of the first schedule to the Electoral Act. Well, if an application to remove the name of a party from a petition and would involve facts and points of law together with exhibits involving superior decisions, it would definitely be such that affects the strict timing of the petition as a whole. Because processes will be involved, and in the final analysis, it is the same process that would form part of the final determination. In addition, a perusal of the address of respective counsel was not seriously persuasive, but rather the appellant did not press the point nor make it an issue of timing of the hearing of the application. It stands smacks of a tacit consent on the part of the appellant amidst emphatic addresses that the application be heard along with the petition. There was no alleged miscarriage of justice that would occur. Hence, this impressed on the tribunal in making a ruling backing up the change. The discussion has to do with the directions as to the manner in which the question or issue by the court or judge in chambers will be dealt with. What the appellant is canvassing amounts to wresting the power of discretion from the tribunal. On the whole, there has been no constitutional breach of any rights by the tribunal, and I so hold. I resolve issue 1 against the appellant. The appellant go on, having read the several Supreme Court judgments generated by respective parties, either from the primaries or election or under petition, especially the judgment in SC 971/20 in Ararume against Dubai, where the Supreme Court set aside the judgment of the Federal High Court in disqualifying the fourth respondent, that is Chukwumai Bezim, because he was not made a party. There is yet another Supreme Court appeal yet to be delivered, which also touched on the motion in this matter. Therefore, would the tribunal be right to proceed to effect a Supreme Court judgment as submitted, when in actual fact it is the non-joinder and misjoinder by the first court of instance that was nullified? It would be premature at that stage to rush to hear the motion when more decisions are yet to come. The entire scenario has to be carefully examined by the tribunal, and this can only be done at a full hearing when all exhibits and different judgments affecting the issues would be demonstrated holistically by parties. I'm afraid, as the matter stands, given the peculiar circumstances, it would not be correct to submit that the tribunal refused to give effect to the Supreme Court's judgment. It is tried that every judgment thrives on the facts of the case and points of law decided. Hence, the doctrine of stare decisis applies mutandis mutandis. It is also in this vein that this court will refuse to invoke Section 15 of the Court of Appeal Act, supra. The conditions for it has not arisen. I resolve issue 2 against the appellant. On the whole, having resolved the 2 issues against the appellant, this appeal fails and lacks merit, is hereby dismissed. Cost of 350,000 is awarded against the appellant. There is a cross appeal. I'll proceed to take the cross appeal. Cross appeal filed by the second respondent, cross appellant, pursuant to notice of appeal filed on the 9th of March 2021 against the decision of the National Assembly Election Petition Tribunal sitting in Owerri. Cross appeal distilled one sole ground. Thus, the brief was filed on the 17th of March 2021, and I've reproduced the grounds here. The third respondent also filed his brief, 19 March 2021. The third cross-respondent filed raised a notice of preliminary objection at page 2 of his brief to strike out the cross-appeal, which was argued in the brief as incompetent and the court lacks jurisdiction. I will produce the grounds of his preliminary objection. The fourth appellant's brief filed, the first cross-respondent's brief filed on the 19th of March 2021. Also, he raised a preliminary objection, which is on all fours with the third cross-respondent, which he argued in the brief at pages 2 of his brief. Preliminary objection shall be addressed later in this judgment. We have captured the arguments of all the parties, and to go straight to the preliminary objection of the third and the fourth cross-respondents, the arguments are taken together since they all are aligned on the same page. The third and fourth respondent will produce the proceedings of 22-21 before the tribunal, where Chief A.O. Ajana applied for his motion to be taken, and the court ruled that the motion be adjourned to 24-2021 for hearing, while other preliminary interlocutory motions be taken alongside the final address. He referred to section 241 of the Constitution that right of appeal, which is by an aggrieved person, and that this does not inure the cross appellant. He cited, I'll take the arguments I've read so as not to bore you. I'll go straight to the resolution of the preliminary objection. And I shall take it from page 47. So the sole issue herein, which is from the sole ground, is incompetent, having not aligned with the particulars. It is and is incompetent without the particulars. The sole ground and issue cannot stand as is predicated on nothing. It's rendered incompetent. In addition, it is therefore clear that the ground do not flow from the ratio of the decision. There was no refusal by the tribunal to take the cross appellant's motion of 23rd of February 2021 in the decision. It is contrary to the proceedings of the 22nd and the 24th. More also, there is a challenge of the record before the court. It is presumed that there is no challenge of the record before the court, is presumed to be correct. Third and fourth cross respondent has contended that the appeal is an abuse of court process. I've examined the process and arguments above and can't but agree that this is a clear frivolous appeal without any legs to stand. It appears to have been filed for the sake of toying with the courts or following the bandwagon. Where there is no grievance, the cross appellant has imagined one. The court has held on the question whether the court can strike out or dismiss the proceedings before it, when satisfied that it amounts to abuse of court process. I've reproduced the ratio in Okonkwo and FRN, and we went on to say, therefore, in our strong belief that this appeal cannot be allowed to progress beyond this point, as it has become an academic thesis, it has nothing to stand on, it is speculative and an attempt to taunt the wheels of judiciary, which amounts to an abuse of court process. Therefore, this appeal stands dismissed. The preliminary objection of the third and fourth cross-respondent succeeds and is upheld. Consequentially, the appeal is dismissed. Cost of 250,000 is awarded against the cross-appellant and in favor of the third and the fourth respondents.
My learned brother, Abubakar Dati Yaya, sent in a contribution agreeing with the judgment in respect of the appeal and the cross appeal, and also abiding by the orders to cost. I have equally had the privilege of reading the draft of the lead judgment just read by my learned brother Abibola Obasekere Jun JCA, and I totally endorse the reason and conclusion therein, and I also adopt the consequential orders in the lead judgment as mine.
As God pleases.
As God pleases.
Both of you, both of you.
Yes, register. Let's go to the last one.
As the court pleases. Judgment. Appeal number CA/OW/EPT/SEN/4/2021 between Senator Ifeanyi Godwin Ararume and Young Progressives Party (YPP) and 3 others. Parties are absent, my lords.
Yes, any appearance here?
A. Olajide for the appellant. W.A. Olajide for the appellant, my lords.
Thank you. Any further appearance?
Yes,
JM, my lord.
Yes.
JM Matthew, my lord, for Frank Imbezim, 4th respondent. Sir.
Mr. Famabo, you are for the 3rd.
Yes, with due respect, my lords, Gio Formabo for the 3rd respondent, sir. I'm grateful.
The first and the second respondents, were they served? Registrar. Young Progressive Party, was it served? And the All Progressive Congress? Or Dr. Wadigo, are you still with us?
Dr. Wandigo, my lord, is having network issues.
He's appearing for the
APC, my lord.
For the second respondent, right?
Yes, my lord.
What of the first? Registrar, was the first respondent served?
Yes, my lord. The first respondent was served on the 20th of April.
My learned brother shall take this judgment.
This judgment was delivered or was prepared by my Lord Abubakar Dati Yahya GCA. Mandated me to read it as his judgment on his behalf. I shall proceed to make the pronouncement. Judgment. This appeal has emanated from the ruling of the National Assembly Election Petition Tribunal, where it delivered on the 26th of February 2021. The 3rd respondent hearing, INEC concluded a by-election for the Imo North Senatorial District on the 5th of December 2020. Being dissatisfied with the result of the said election, the first respondent hearing, the YPP, presented a petition to the tribunal, praying the second respondent hearing, that is APC, that the 4th respondent, Chukuma Francis Bezim, and the appellant hearing are not qualified to contest the election. On the issue of service, the tribunal made an order for substituted service of the petition and other processes on APC and Senator Ifeanyi Godwin Ararume, who were the 1st and 4th respondents at the petition. All respondents to the petition except the 4th respondent filed their replies. Then the 4th respondent, who is now the appellant, filed an application on the 15th of February 2021, praying this tribunal to set aside the order for substituted service and the service of the petition, for the tribunal to compel the second respondent to deliver the petition to him. After arguments, the tribunal on the 26th of February 2021 refused the application, hence this appeal. Respective parties filed their briefs, and we shall go straight to the preliminary objection. In the meantime, the 3rd respondent did not file a brief, and the preliminary objection was that ground one of the grounds of appeal and issue one in the brief of argument do not derive from the ruling appealed against. Against this background, we capture the arguments of parties, and this is what we have to say. Surprise? Okay. We have looked at ground one of the appeal and issues distilled from it. We have paid close attention to the ruling giving birth to the appeal. And we find that the tribunal refused the application mainly on the ground that the applicant misconceived the order of the tribunal, which was that the petition was to be served by subsisted service on the third respondent. We have reproduced the order which was made by the tribunal. Tribunal made reference to time, but even on this, it was in respect of time to file a reply to the petition and not the application. We produce say, and at the end we say, in our view, this is what sets off the appellant. Although he's wrong, I take the stand that this is an election petition matter that evokes lots of passion and technical rules of court when employed unnecessarily, and it tends to jeopardize democratic perception. I therefore overlook the blunder in this respect. Regarding the facts and the nature of the action, I sustain ground one and the issue distilled from it, and I discountenance the preliminary objection. Now we'll go straight to the appeal on merits. We produced issue one, the ground of appeal, and we'll go straight to conclusion. I'll take it from okay, at the end, conclusion one. It says, from all the above, it is crystal clear that the tribunal was right when it dismissed the application to set aside the order for solicited service. The service itself, or to compel the second respondent hearing to release the petition to the appellant. Issue one is thus resolved against the appellant and in favor of the first, second, and fourth respondents. On issue two, whether the learned trial judges of the tribunal were right in law when they woefully failed to compel the second respondent to serve the appellant with a copy of the petition meant for service on the appellant and thereby deny the appellant's fundamental right to fair hearing the said petition. Well, upon the analysis, in finality, this is what we have to say. Well, that therefore, since the appellant has been served and has been given the opportunity to be heard on the petition, but he failed to avail himself of that opportunity, he cannot complain, and his right to fair hearing has not been breached. Issue number two is thus resolved in favor of the first, second, and fourth respondents and against the appellant. This appeal lacks merit in its totality, it fails and is hereby dismissed. 2,500 naira cost to the 250,000 naira cost to the first, second, and fourth respondent against.
So, we agree to my lord.
Yes, I had the privilege of reading the draft of this judgment before it was delivered, and I totally agreed with the lead judgment as read. I also dismissed the appeal as lacking in merit.
I sent in my
as the court pleases.
to the judgment, and I also agree and abide by consequential orders made.
As the court pleases.
So thank you, gentlemen, for being with us despite all the hitches and technicalities, but we believe that all is well that ends well. And of course, we also say thank you to our support staff and the technical crew that you cannot see, who have made all this possible. So the court will rise now.
No, it's 250.